Instead of packing up his bags when the Supreme Court said the president is immune from almost everything, Jack Smith said screw it, re-indicted the former president, and included a whole bunch of new evidence for the former president's crimes. When life gives you lemons, you make lemonade, even if it's criminal lemonade. I don't know, the metaphor breaks down. So Jack Smith is trying to make lemonade with a 165-page motion laying out all the ways that Donald Trump tried to overturn the 2020 election results, and it includes a whole bunch of new bombshells. You might recall that Smith was forced into this position by the Supreme Court, which ruled that Trump was almost certainly immune from criminal prosecutions for trying to overthrow the government, as long as he was doing president-like things while breaking the law. Justice John Roberts told Smith that he could rebut the presumption that Trump was above the law, but didn't tell him how to do it. So here we are now with hard mode activated. Smith first filed a superseding indictment removing things that were clearly off limits, now, according to the Supreme Court for the first time, like Trump weaponizing the Department of Justice with the help of power-mad environmental lawyer Jeffrey Clark. Smith's new brief is a granular analysis of everything that Trump did to cling to power. The motion divides Trump's acts into things that he did in the service of his campaign, which are presumably fair game, versus things that he did as president, which are presumably strictly off limits. So in response to the Supreme Court in U.S. versus Trump, Jack Smith had to go back and basically do a mini-trial to make sure that the claims that he alleged would pass constitutional muster. And while the Supreme Court didn't make it clear what exactly needed to happen, at a bare minimum, we know that Smith needed to make a prima facie case on both the facts and the law before proceeding. So Smith apparently put his best evidence and legal arguments forward. Meanwhile, Smith's motion was treated as breaking news by even Fox. Anchor Neil Cavuto reported,
in this newly unsealed court paper, we're learning that former President Trump resorted to crimes in a bid to cling to power after the 2020 election.
So let's break down all the new stuff that we learned about Trump's 2020 coup attempt. Now, Donald Trump has been on the national political scene for over 9 years now, and during this time, Congress and the courts have treated his attempts to interfere with elections as a hot potato that they have to toss back and forth. And this started with the Mueller report's finding that Trump may have committed 10 acts of obstruction of justice, but Mueller concluded that Congress was responsible for holding him accountable. Congress said no thanks. Then in 2020, Trump lost to Joe Biden. Months of drama followed, ending with Trump supporters rioting at the Capitol on the day that Congress was supposed to certify the result. Now, the principle of presidential immunity protects the president from certain civil acts and some criminal prosecutions during their time in office. In Trump versus United States, the Supreme Court ruled that presidents enjoy a strong presumption of immunity for any official act undertaken while president. And the ruling prevents prosecutors from using official acts as evidence in a criminal case, even if the presidential acts are related to private conduct. To overcome that presidential immunity, the prosecution has to prove that there are, quote, no dangers of intrusion on the authority and functions of the executive branch, with no other factors to consider. The court also gave the president absolute immunity for certain core presidential functions, and Justice Roberts interpreted core functions so broadly that they might even encompass a president ordering a Department of Justice to conduct a sham investigation into allegations of fraud the president knows are fake. District Court Judge Tanya Chutkan in D.C. must now determine whether Trump is immune for the actions he took to overturn the 2020 election. And Judge Chutkan granted Smith's motion to file a motion on the immunity determination and allowed Smith to file a redacted version on the public docket. She also allowed him to file a much longer brief than would normally be allowed for motion practice. But in that brief, Smith argues that the court should draw a line between Trump's actions as president and his actions as a private candidate for president. Quote, the defendant asserts that he is immune from prosecution for his criminal scheme to overturn the 2020 presidential election because, he claims, it entailed official conduct. Not so. Although the defendant was the incumbent president during the charged conspiracies, his scheme was fundamentally a private one. Working with a team of private co-conspirators, the defendant acted as a candidate when he pursued multiple criminal means to disrupt, through fraud and deceit, the government function by which votes are collected and counted, a function in which the defendant, as president, had no official role. This brief is Smith's attempt to show Judge Chutkan in the courts of appeal that Trump is not immune. And as I said, the Supreme Court didn't give a lot of guidance on how to apply its decision, and said nothing about how the presumption of immunity could be rebutted. And faced with this problem, Smith relies heavily on the D.C. Circuit Court decision in Trump versus Blazingame, a civil suit about whether Trump was entitled to absolute presidential immunity for allegedly inciting the January 6th riot. In that case, the Blazingame court held that the president is not entitled to civil immunity when he's acting as an office seeker rather than an office holder. The court said, quote, when a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of the presidency as an institution is agnostic about who will occupy it next, and campaigning to gain the office is not an official act of the office. So when a sitting president running for a second term attends a private fundraiser for his re-election effort, hires or fires his campaign staff, cuts a political ad supporting his candidacy, or speaks at a campaign rally funded and organized by his re-election campaign committee, he is not carrying out the official duties of the presidency. He's acting as an office seeker, not an office holder. No less than are the persons running against him when they take precisely the same actions in their competing campaigns to attain precisely the same office. And Smith embraces this rationale. Quote, consistent with the D.C. Circuit's opinion in Blazing Game, the Supreme Court suggested that a president who speaks as a candidate for office or party leader, as the defendant did here, does not act in his official presidential capacity. As the D.C. Circuit explained, a president acting as a candidate for re-election is, to that extent, not carrying out an official responsibility. Now, obviously, if you tried to overturn a democratic election, you'd want a good lawyer, not any of the scummy and villainous lawyers that Trump actually had. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your recovery and at least find out what your options are going forward. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click below. Now, turning to the new alleged facts and evidence that were presented, according to the brief, Mike Pence spent weeks trying to convince his boss to stop trying to deny that he lost. On November 7th, Pence started with flattery, telling Trump he, quote, took a dying political party and gave it a new lease on life. Pence next attended 2 meetings where lawyers explained that Trump would probably lose all of the pending lawsuits. On November 12th, Pence had a private lunch with Trump where, quote, Pence reiterated a face-saving option for the defendant. Don't concede, but realize the process is over. They had another private lunch on November 12th where Pence attempted to get Trump to give up but just run again in 2024. And as December wore on, Pence tried to usher Trump through the stages of grief, telling him, quote, not to look at the election as a loss, just an intermission. In response, Trump allegedly pressured Pence to violate his oath of office by rejecting slates of electors from swing states Biden won. And during the riot, Trump was at best indifferent to Pence's physical safety. When rioters breached the Capitol building, Trump sent an infamous tweet at 2:24 p.m., quote, Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not the fraudulent or inaccurate ones, which they were asked to previously certify. USA demands the truth. And when rioters got to within 40 feet of Pence, the Secret Service had to evacuate him. But when Trump's team told him that Pence was in harm's way, he allegedly responded, so what? Yeah. So the government's filing indicates that they plan to introduce evidence from Trump's cell phone if they go to trial. And according to the government, Trump was all alone in the dining room when he sent that tweet, and he was acting as a candidate, not the president. Quote, the content of the 2:24 p.m. tweet was not a message sent to address a matter of public concern and ease unrest. It was the message of an angry candidate upon the realization he would lose power. Trump's advisors urged him to call off his dogs, but Trump waited 14 minutes to tweet, and when he did, he said, please support our Capitol Police and law enforcement. They are truly on the side of our country. Stay peaceful. But his aides didn't think this was good enough since the riot was still going on, so Trump followed that up with a video message at 4:17 where he said he loved the rioters. Then at 6:01, Trump tweeted, go home with love and in peace. Remember this day forever.
So go home. We love you. You're very special.
But under the court's decision in Trump versus U.S., these were arguably official acts, so Smith had to argue around it. Quote, the defendant at least has an argument, though he issued the 2:38 p.m. and 3:13 p.m. tweets only after being harangued by his staff while he adamantly refused to do anything at all, that he was addressing a matter of public safety as president, the riot at the Capitol. Likewise, in the 4:17 p.m. message, the defendant, while still focused on his election loss, asked rioters to evacuate the breached Capitol and foreshadowed the sentiment in his 6:01 p.m. tweet, when he said to, quote, go home with love and in peace. By contrast, in the 2:24 p.m. tweet, the defendant focused solely on the vice president's role in the certification of the presidential election results, a matter of intense personal concern to the defendant as a candidate for office. Even assuming that the topic constituted a matter of public concern, the defendant's 2:24 p.m. tweet reflected speech made in an unofficial private capacity as an office seeker, not an official capacity as an office holder. That's a lot of processing about the 2:24 p.m. tweet, but this is what the prosecution has been reduced to by the Roberts Court. Smith literally has to spend 6 pages explaining why he should be allowed to use a single tweet as evidence of a crime. And he notes that both the Hatch Act and the Supreme Court's decision in Lindeke versus Freed, which confirms that a public official's personal social media account can be used for both personal and public business. Now, Trump argues that his conversations with and about Pence are official acts. And Trump responds that discussions between Pence and Trump about overturning the election results can't be official acts because neither office plays a role in determining the outcome of the election. Quote, the government is aware of no contrary evidence, including of any president other than the defendant, seeking to influence his vice president in the discharge of his duties as president of the Senate in presiding over the joint session. The absence of any such historical tradition is reinforced by the fact that in 22 of the 59 certification proceedings, the vice president has not presided at all. When it comes to the certification proceedings specifically, not only has the president been deliberately excluded from the process, but the vice president's role as president of the Senate is highly circumscribed and ministerial in nature. Smith also provides new evidence that Trump's cronies wanted to incite a riot. Quote, in the immediate post-election period, while the defendant claimed fraud without proof, his private operatives sought to create chaos rather than seek clarity at polling places where states were continuing to tabulate votes. For example, on November 4th, when votes were being counted at a tabulation center in Detroit, someone pointed out that, quote, we think a batch of votes heavily in Biden's favor is right. A person identified as P5, who is a campaign employee, agent, and co-conspirator, said, quote, find me a reason it isn't. Then another person brought up the, quote, Brooks Brothers riot, a political protest that took place on November 22nd, 2000, at the Miami-Dade County Canvassing Board office. The protesters were a group of Republican operatives who were demanding an end to the recount process in Bush versus Gore.
Stop the count, stop the fraud, stop the count, stop the fraud, stop the count, stop the fraud.
P5 replied, make them riot and do it, with 3 exclamation points, which suggests the Trump campaign was eager to interrupt the vote counting by any means necessary, including violence. And Smith also argues that under the Hatch Act, White House staff can wear 2 hats as campaign staff and executive branch authorities, but they can't wear them at the same time. Quote, simply because a staffer holds a title in the executive branch and interacts with the president does not mean that the interaction is necessarily official. For example, P15, a staffer, witnessed a conversation between Trump, Melania, Ivanka, and Jared Kushner aboard Marine One, where Trump unprompted said, quote, it doesn't matter if you won or lost the election, you still have to fight like hell. Smith argues, quote, this statement is plainly private. It was exclusively about the election and the defendant's determination as a candidate to remain in power whether he won or lost. If the judge allows P15 to testify, he will say that he did not participate in the conversation, he was just an observer. And I look forward to hearing what the Supreme Court justices say about this interaction. We should expect their decision sometime in 2031. And when Trump was trying to overturn Biden's victory, he threatened to fire the acting attorney general because he would not confirm Trump's election fraud claims. But Justice John Roberts wrote that this implicated the, quote, investigative and prosecutorial decision-making authority that is the special providence of the executive branch. Roberts concluded that a president's official duties included communicating with the DOJ to ensure there isn't election fraud. And this is probably one of the worst parts of the court's decision because it seemed to confirm Richard Nixon's belief that when the president does it, it's not illegal. But what about all the times that Trump communicated with staff officials about overturning the results? Well, Smith argues that unlike his conversations with the DOJ, these can't be official acts because the president doesn't have a role to play in the ascertainment of electors. Quote, as president, the defendant had no official responsibilities related to the state's administration of the election or the appointment of their electors, and instead contacted state officials in his capacity as a candidate. Tellingly, the defendant contacted only state officials who were in his political party and were his political supporters, and only in states that he had lost. Smith argues that if Trump was really concerned about fraud, he would have called up Democrats and governors in states he won or reached out to candidates who lost their own races. But Trump didn't care about any race other than his own. Moreover, the motion includes reams of evidence suggesting that Trump knew his fraud claims were false. Quote, at trial, the government will elicit testimony from election officials from the targeted states to establish the objective falsity and often impossibility of the defendant's fraud claims. Notably, although these election officials would have been the best sources of information to determine whether there was any merit to specific allegations of election fraud in their states, the defendant has never contacted any of them to ask. History confirms that presidents have never understood their wide-ranging duties to encompass any direct role in the function of collecting, counting, and certifying the result of a presidential election. Now, we also know that Trump had a scheme to overturn the election by using fake electors. This also is illegal. But the Trump versus U.S. decision means that Smith has to explain why the president, unlike his co-conspirators, isn't above the law. And one way Smith does this is by arguing that the president kept some White House personnel away from those conversations. For example, he included his private lawyers to pressure Pence. That's arguably outside the scope of any executive function. Moreover, Trump excluded the White House counsel from a meeting about the fake electors and the role that Pence was supposed to play in the scheme. Smith says, quote, it is hard to imagine stronger evidence that conduct is private than when the president excludes his White House counsel and only wishes to have his private counsel present. And Trump's attempt to change the election results ran mostly through Rudy Giuliani and his team of private lawyers. One senior Trump campaign advisor was exasperated with the obviously wrong legal claims. This person claimed that Trump's wacko legal team was the Star Wars bar after the cantina scene in Star Wars. Quote, "When our research and legal team can't back up any of their claims made by our elite force strike team, you can see why we're 0-32 on our cases. I'll obviously hustle to help on all fronts, but it's tough to own all of this when it's just conspiracy shit beamed down from the mothership."
You will never find a more wretched hive of scum and villainy.
The Star Wars bar included legal luminaries like Rudy Giuliani, Jenna Ellis, and Sidney Powell. And Trump theoretically knew that his legal claims were bogus. On November 20th, during a conference call with the Kraken herself, Trump muted her, called her crazy, and made a reference to Star Trek when describing her allegations. Now, unbelievably, Jack Smith doesn't tell us what this Star Trek reference was. If only we knew. Which character is Donald Trump? Who is Sidney Powell? And just how crazy is Powell that you have to make a metaphor based on extraterrestrial fiction? But let us know what you think the reference is down in the comments. Now, generally, Smith did a pretty good job in a tough circumstance. And there is obviously compelling evidence that the president tried to remain in power by creating fake voters and fraud claims. And it's an indictment of our system that we couldn't put this away before Trump was a candidate in the 2024 election. But as for this DC case, it's safe to assume that Judge Chutkan will rule that at least some of the evidence can be properly admitted at trial. But Trump will definitely appeal her decision to the DC Circuit, and he will appeal that decision to the Supreme Court. And the ultimate outcome of this case will largely depend on how much the Supreme Court will embrace the DC Circuit's decision in Blazingame in the criminal context. Will the court agree that campaigning to gain the presidency is not an official act of the office? Or will the Supreme Court just go full Nixon and say, if the president did it, and even if it's campaigning, it still counts as a presidential official act? Now, obviously, people on both sides of the aisle are up in arms about all of these cases, and it's also reflected in news reporting as well. But what's interesting is that Jack Smith's superseding indictment of Donald Trump has been covered extensively by over 400 news outlets. Now, 40% of the reporting is coming from the left, and only 24% is coming from the right. But if you compare the headlines, you'll start to see some interesting frames emerge. On the left, you had one news outlet framing the indictment by arguing that the Supreme Court will unjustly give Trump immunity. And on the right, you might see the opinion of Republican Representative Rick Scott, who called the superseding indictment complete election interference. And depending on which article you saw first, your view of the story would be completely different. If you read left-leaning news sources, you might feel grateful that Jack Smith is on the ball, fighting for justice against Trump and the partisan Supreme Court. And if you lean right, you might think this whole deal is overblown and that Trump had a right to question the outcome of the election, as with this headline from the noted objective legal news source, The Federalist. Now, all this is possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. Ground News is my absolute favorite way to read the news. Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. And one of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum, like the superseding indictment. It helps explain why we often talk past each other and why some people seem hyper-focused on what seems like complete nonsense, often because some random blog post went viral among certain people. But either way, Ground News is fantastic. And as a legal eaglet, you can save 40% off of the Ground News Vantage subscription by clicking on the link that's on screen right now or down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link that's on screen right now or down below to get a 40% discount off of the Ground News Vantage subscription and get all the Ground News tools. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.